This video is the second part of obligations and contracts under the Civil Code of the Philippines. Contract. It is a meeting of the minds, with respect to the other, to give something or to render some service. Art 1305. A contract is a meeting of minds between two persons whereby one binds himself, with respect to the other, to give something or to render some service. Elements. 1. Consent. 2. Object. 3. Cause. Types depends on perfection of the contract. 1. Real, involving real obligation, perfected by consent and delivery. 2. Consensual, personal obligation, perfected by meeting of the minds. 3. Solemn, must execute the proper form. Requires certain solemnities such as agency to sell real property, donations of real property, partnership where real property is contributed, contract of antichrisis. Characteristics of contracts. 1. Obligatoriness. Contract is the law between the parties, and must be complied with in good faith. 2. Autonomy. The contracting parties may establish such stipulations, clauses, terms and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. Case. Time and again, we have stressed the rule that a contract is the law between the parties, and courts have no choice but to enforce such contract so long as it is not contrary to law, morals, good customs, or public policy. Otherwise, courts would be interfering with the freedom of contract of the parties. 3. Mutuality. Contracts bind all parties, and the validity and compliance of contracts cannot be left to the will of one of the parties. 4. Relativity. General rule. Contracts take effect only between 1. The parties, 2. Assigns, the persons to whom the contract or rights and obligations are transferred, and 3. Heirs, persons who will inherit in case of death of the parties. Exception, third person may be affected. A. Stipulation por autrui. B. Tortious interference. C. Acción poliana. Stipulation por autrui. Requisites. 1. The contract contains a stipulation in favor of a third person. 2. The stipulation in favor of third person must be only part and not the whole of the contract. A. If it is the entire contract, that third person becomes a party in the contract. 3. The contracting parties clearly and deliberately conferred a favor upon a third person and not merely incidental benefit or interest. 4. The favorable stipulation must not be compensated by any obligation. Otherwise, it becomes a three-way contract. 5. The third person must communicate his acceptance to the obligor before its revocation. 6. The contracting parties are not legal representatives or duly authorized by the third person to enter into the contract that gives the latter benefit. If legal representative, then there is no actually third person. A. Essential elements. Consent. It is manifested by the meeting of the offer and acceptance upon the thing and the cause which are to constitute the contract. Rules as to the offer and acceptance. An offer is a manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it. Must be clear. The offer must be certain and the acceptance absolute. A qualified acceptance constitutes a counteroffer. There is no perfected contract if the offeree will not accept but will just make a counteroffer. If the acceptance is qualified, the same is considered a counteroffer. Acceptance means signification of conformity with all the terms of the offer. The acceptance must be unqualified and unconditional. Vices of consent. 1. Mistake as to the thing, conditions, or the identity of a party. 2. Intimidation, reasonable fear of an impending and grave evil, moral. 3. violence, serious or irresistible force, physical. 4. Undue influence, improper advantage of power over the will of another. 5. Fraud, deception, insidious machinations and manipulations. Dolo causant, ground for annulment of contract. Case. Spouses de Vera v. Cotungo. In determining whether consent is vitiated by any of these circumstances, courts are given a wide latitude in weighing the facts or circumstances in a given case and in deciding in favor of what they believe actually occurred, considering the age, physical infirmity, intelligence, relationship, and conduct of the parties at the time of the execution of the contract and subsequent thereto, irrespective of whether the contract is in a public or private writing. When one of the contracting parties is unable to read or is otherwise illiterate, and fraud is alleged, a presumption that there is fraud or mistake in obtaining consent of that party arises. Second element. Object. Within the commerce of man. Things and services are outside the commerce of man if they cannot be appropriated or they incapable of private ownership or if they are intransmissible. If the contract involves land of public domain, not valid, not within the commerce of man. Licit and not contrary to law, morals, good customs, etc. Must not be impossible, physically, legally, and practically. Must be determinate or at least determinable. The thing must be determinate as to its kind and quantity. This is determinable if the same can be determined without that need to enter into an agreement. Third element. Cause or consideration. In onerous contracts, the prestation or promise of a thing or service by the other. In remuneratory contracts, the service or benefit which is remunerated. In gratuitous contracts, the mere liberality of the benefactor. It must be licit or lawful. Basic principles of contracts. Interpretation of contracts. If terms are clear and unambiguous, the literal meaning of the terms used is the controlling factor. If the meaning of the words is contrary to the evident intent, then evident intent prevails. Contract of adhesion. One party prepares the stipulation in the contract, while the other party merely affixes his signature or his adhesion thereto, giving no room for negotiation and depriving the latter of the opportunity to bargain on equal footing. Not invalid per se. The terms of which must be interpreted and enforced stringently against the party which prepared the contract. Insurance, bank documents, mortgage contract. Freedom to stipulate, autonomy of the will, and its limitation. In one case, the Supreme Court held that, in view of this, it is well to remember that a contract is the law between the parties. Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. The parties are allowed by law to enter into stipulations, clauses, terms and conditions they may deem convenient which bind the parties as long as they are not contrary to law, morals, good customs, public order or policy. Privity of contract. The Supreme Court held that the parties to a contract are the real parties in interest in an action upon it. As such, the basic principle of relativity of contracts is that contracts can only bind the parties who entered into it, and cannot favor or prejudice a third person, even if he is aware of such contract and has acted with knowledge thereof. Where there is no privity of contract, there is likewise no obligation or liability to speak about. Thank you for watching. Next part is part 3 of the obligations and contracts, covering the topics under defective contracts. Please like and subscribe to my channel for more updates.